When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com.
Good evening. Welcome once again to another episode of Truth and Justice TV. Thanks for joining me, Jennifer OBASEKI, who's going to be telling you what's new when it comes down to immigration law. But before we do that and before we see our special guest, have you seen the papers? This month of January has seen 43 stabbings. And despite that number, the Secretary of State seems to have reduced the money that's being spent on knife crime prevention. I'm not quite sure how you see or interpret that, but I'm so deeply concerned that I thought that we're going to do a special program on that topic. And we have invited some police officers and community activists to that program because it's very important that we look at the root causes. There are a lot of organizations out there to help families as well. And I'm not sure whether if you are dealing with a troubled teen, a teen that's being groomed, whether you know what to do or where to go. It's very easy to call the police, but unless the child is being caught in a crime or unless the child is actively caught with drugs or a knife on them, it may be difficult for the police to act, and the referral mechanisms are not always quite clear. So we'll be doing a very special program specifically looking at gangs and knife crime. Why are children carrying knives? Is it for protection? Is it for prevention? Is it because they're actually carrying out attacks? We need to know. We need to know those root causes. And apart from that, we've had some interesting news. The EU portal that we were talking about that has been now downloadable app means that if you're an EU national, you can make your applications and they're free. So if you are an EEA national or you're a dependent of one, you need to apply for your settled status. You need to apply for residence permit. It's so important because whether it's a hard Brexit or a soft Brexit, it confirms your status here in the UK and it will allow under the transitional provisions for you and your family and your dependents to be protected. The other thing that we keep encouraging you to do is if you're an EEA national and you actually have dependents that are outside of the EU, please try and invite them to come in now. Please try and invite them to come in now as your dependents while this window is still open. Okay? And then apart from that, there were some worrying statistics that were shown last week, which were the fact that in incarceration, the percentage of males from ethnic groups is staggeringly high compared to their reflection in the national population. So within the detained centres, so you're talking about prisons, young offenders institutions, they are overly represented, coming up towards 50%, whereas in the national population, there's just under 12 or between 12 and 14%. So that's a deeply, deeply worrying statistic. It's even less than that. So what's making black men and ethnic minorities be overly represented within the criminal justice system? Again, circumstances we're going to look at that school to prison trajectory, and one of the only organizations that I've seen really focusing on this is the Black Child Agenda. The Black Child Agenda, it's a very, very good organization that's trying to look at these causational factors within the community that's making people or our youth just go on that one trajectory from school, exclusion, crime, prison, and trying to stop that trajectory, which is more important. So, yes, lots of changes and definitely lots to talk about in future episodes. But today, it's all about what's new with immigration. And today, my special guest is Mr. Marcus Muirhead. So, Mr. Marcus Muirhead, for those of them out there that don't know you, please introduce yourself.
Okay, I'm an immigration advisor who has been working for OBASEKI Solicitors for coming on 9 years. I'm the Deputy Head of Immigration and I'm also Head of the Immigration Appeals Department.
Now, if somebody says to you, well, immigration advisor, but what qualifications do you have and where do you go to court? What would you say to them?
Okay, I often get asked that question. I always make it clear that I'm not actually a solicitor. However, my legal background in terms of academics is I have a law degree and I have two master's degrees. I've actually undertaken a number of immigration courses and I regularly attend immigration tribunal appeals, both in the first tier tribunal and in the upper tier tribunal.
But what's even more important is your success rate is 98%.
I wouldn't necessarily go as high as 98%.
I would.
It's in the high 90s. Yes, definitely.
Exactly, and that's what's important. If you're going to an advisor, you've got to look at their experience and their track record. Now, apart from appearing in the upper tribunal, having the utmost respect of judges, what would you say has been your most complex case so far?
Most complex case, I would say, is dealing with the rules in terms of immigration and adoption, international adoption, because they're highly technical, and my experience, what I've discovered in experience, is not even the judges are fully aware of the different rules and what I would say is requirements in respect of meeting those rules, and also the fact that within those rules you can be criminalized if you do not follow the correct procedure in terms of having the adoption recognized by the UK government.
Now, adoption, international adoption, that's one very, very busy area. But at the same time, what is new? We've heard about the Windrush, we've heard about the immigration app. So those people out there that may have immigration concerns or the concerns with regards to people in their church or their mosques, what can you highlight with regards to the Windrush scheme?
Right. In respect of the Windrush scheme, what I think is the biggest issue is people do not understand how it operates. So, for example, a lot of people assume that the Windrush scheme only applies to those people that who have come from the English-speaking Caribbean, where in fact it applies to a number of African countries and various countries around Asia, and the countries that qualify under the Windrush scheme are usually countries which fall within the Commonwealth.
And then at the same time as it applying to people who've come from the whole Commonwealth, not just the English-speaking Caribbean, it might be worth maybe reminding people that it's not just people who are in the UK that the Windrush scheme applies to. It also applies to people who may be outside or that have left and either been denied re-entry or that are not even sure, that left with settled status and wanted to return. So if you explain to some of the elements of the Windrush scheme that some people may not be aware of.
Okay. Under the Windrush policy, in terms of if you are currently outside the UK, the main issue to consider is whether the person is a Commonwealth citizen and was settled in the United Kingdom before the 1st of January 1973, and their settled status lapsed either because they left the UK for a period of more than 2 years. And what the Home Office have done is there's an online form for people who are outside the UK that can use that form, complete it, and apply. Now, the type of leave that they are given depends on their circumstances, and it also depends on what they actually request. So the Home Office guidance states that you can be granted indefinite leave to remain, i.e. permanent residence, or you can be given leave to return to the UK as a returning resident. And there's even an option that if you, for those who don't actually wish to come back and live in the UK, but they still have family here, friends here that they would like to visit, they can get a 10-year multiple entry visit visa, which
10-year multiple
would allow them to enter the UK for 6 months at a time and last for a 10-year period.
Okay, now at the same time, we've seen the app being open online. That's for EU nationals. And would you follow through that many people don't seem to be using that provision to make their applications? And I understand that it's free, no more £65.
Yes, the app is free. However, until March, when it becomes fully in use, because it's only partly in use at the moment, currently there's only certain people that can use the app. So if you are an EEA or EU national and you have been in the UK and you're working, you have a presence in the UK, you can use the app. Your dependents can only use the app if you are applying at the same time as them. Also, if you are an EEA or EU national and you are here as a student or what they term self-sufficient person, then you are also prevented from using the app until its full rollout in March.
Okay. Now, the fact that it's free, the fact that very little checks are being done, in the sense that it's an online application, they're going to check, a lot of the checks are being done in the background. We recommend that you strongly recommend that you actually take this up. And again, if you have dependents outside of the EU that you've been supporting, sponsoring, please think about whether you want them to be here with you, because now's the time to make that application. One of the things that really does worry me is the fact that there's a lot of fake advice going out there on WhatsApp groups. Even this weekend, a highly educated, informed person I know called me to say, well, she heard a lawyer saying that British people can apply for their foreign national relatives to stay with them just before they leave the EU. And I'm like, well, that's not true. You've got to be careful. Then other people being advised, oh, the Home Office is granted an amnesty under the table. And I've given warnings about this in the past. Can you please clarify these two fake rumours that are being circulated at the moment?
In respect of the purported amnesty that the Home Office are giving, I've had a number of clients, as you yourself have, who have messaged me, come into the office and saying, I've been sent this message and it has a form that's called SET-P. What I often advise my clients is you will always find somebody who tells you that, yes, it works, I've been told it works. And the response I give is show me not the text, show me the person who has actually used it successfully. What you note from this route that's being suggested to people is that when you actually look on the form, it's a form that says protection. So it's a form that's designed for people to apply for indefinite leave to remain who have been previously granted humanitarian protection. And if they have not been granted humanitarian protection, then that route and that form does not apply to them, and all that will happen is they will spend a significant amount of money on the application.
And with lawyers that gave you the wrong advice.
And it will be refused.
But
I've
not
seen
only,
it happen
yeah,
so many times.
too many times. And not only that, the Home Office will actually know where you are. You may be asked to conform to reporting regime. So before you make an application, make sure you're entitled to do so. And even if it's going to be made on discretionary grounds outside the rules, take advice so that it's done in the right manner. Apart from that, some common mistakes people make, because we've seen people get a lot of the discretionary leave to remain rolling. So that's people who either get indefinite leave to remain after 6 years or 3 renewals, or you get indefinite leave to remain after 10 years. Some people are making mistakes when it comes down to applying for their naturalization.
Yes.
So, what are some of the common mistakes we're seeing people do around the area of naturalization?
The big issue in terms of naturalization, and I've seen that lawyers have been making
Mistakes.
this mistake. So I would say your viewers need to be very wary. Is under the immigration rules, you have a good character requirement. So in respect of naturalization, you have to have a good record of complying with immigration control, which it says that if you have been in the UK for a certain period of time, so as an example, somebody who under the old rules was granted discretionary leave to remain, they were granted 3 years, they reapply, renew. On their second grant, of completion of their second grant, they've now done 6 years. They apply for indefinite leave to remain, no problem, and then suddenly they say, okay, a year later, I want my British passport, I need to naturalise. Now, what often happens is they go to a lawyer or they put in the application themselves, and the Home Office will write and say, well, we have noted that you entered the UK in 2010, you obtained discretionary leave in 2011, you've had 2 grants, you've been given indefinite leave to remain, but you haven't had 10 years where you have always complied with the immigration rules, because there might be a year or 2 years or 3 years or sometimes more where you've spent that time without any type of leave. And what happens, unfortunately, is a lot of applications are refused on this basis. As I said, a lot of lawyers are making this mistake, so it is a common mistake that people make. But before applying for naturalization, if at any time you had a period as an overstayer, you need to check whether you comply with that 10-year clean immigration history, because more often than not, what the Home Office are doing are refusing those applications, taking your money, and you will be refunded for the grand sum of £80.
£80 only, and if you want to challenge it, the only way to challenge it is to go to the High Court. You have to write a letter before action under the pre-action protocol, but the only way to actually challenge that kind of decision is at a High Court, which can be very expensive. So it's better not to make the mistake in the first place. Just because you're deemed of good character to get indefinite leave to remain does not mean that you qualify under the good character reference for naturalisation. They're 2 different levels of tests. And when I've challenged the Home Office on this, they've been very clear that to get your indefinite, yes, you may have been deemed as a person of good character, but to qualify for a British passport and to have British status, it's a deeper and higher level of scrutiny that you'll be subjected to. So we've talked a lot, and we're going to take a very short break. But after the break, what we're going to be talking about is appeals. We're going to be talking about in-country appeals, out-of-country appeals, whether you should appeal, because at times putting in a fresh application may actually be better and more time and cost saving for you than actually putting in an appeal. So we'll speak to the expert again after this very short break. See you in a moment.
When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020 7739 7549 or go online at www.legalpower.com.
Joining us once again, and as I've said, we're going to be talking about what's new with immigration, what you should be aware of, and for some of you out there, you must know by now that the NHS surcharge, and we warned you last year and we campaigned heavily against it, but despite our best efforts, it has been increased to £1,000. That's staggering for some people. And we'll ask our special guest today, Mr. Muirhead, £1,000. How has that impacted on some of your clients?
It's impacted quite heavily on a number of my clients. Luckily, because we had an idea that this was coming in, we didn't have an exact date. We were just told that sometime in December it would go up. It didn't actually go up until February. What I actually ended up doing was contacting all of my clients who were approaching that time for renewal or were thinking about making an application and saying to them, look, you're going to need to find some money so we can pay the NHS surcharge while it is still £500, because within a few days to a week or two, it will go up to £1,000. And that's happened in the last couple of weeks.
With these applications now, the Home Office, if you put in the application too early, more than 28 days too early, will they even look at it?
Well, what we were actually luckily able to do is we weren't physically putting in the applications, we were just making the NHS
payment.
surcharge.
So you got the reference number.
Yes.
Exactly.
The problem that people may find now is it's actually gone up, but the Home Office have recently put a large set of applications onto their online format. So
people, you need to be fully aware, as we've talked about the app, the Home Office is becoming digitalized now. So Home Office has now set a number of applications for online submission only.
Yes, so if you're applying under family and private life, for instance, if you have a spouse in the UK or you have unmarried partner, or if you have British citizen children or children that have settled status or have been in the UK for 7 years or more, then now all of those applications are done online.
And we still see a lot of people coming with the 7-year rule applications. And I have a policy, which is if there's no barrier to your child reintegrating in their country of origin, don't forget you're supposed to be, as a parent, going with the child, then you've got to be clear that your application may be refused. But is there any other standard advice that people should think about? Because it's not a cheap application to make. Now we've got £1,000 and the application costs £1,033. So that's £2,033 that you will be spending. That's apart from your lawyer's fees if you're going through a lawyer. Any other things that somebody should really think about before taking that risk?
What I tend to advise a lot of my clients personally is, unless there are exceptional circumstances that we have evidence for and we can prove to say why this child should not return to their parents' country of origin, then I often advise my clients to hang on for a bit. If the child was born in the UK, to wait until that child attains the age of 10, then they can be naturalised using Form T as a registration.
And then at the same time, you think about the fact that it's more or less automatic once the child is 10. So if you're a parent and you're thinking about these things, unless you've got categoric clear evidence that your child will not be able to reintegrate in the country of origin, so that's medical, social welfare, risk of harm, clear evidence, then the application is unlikely to be successful. And the case law, time and time again, has proven this. So it's not something that we're just trying to dissuade you from doing. It's something we want you to do, but in an informed manner with the exactly right evidence that's going to actually get you past the goalpost. Now, some people get their leave to remain and have no recourse to public funds. Or some people think about making the application first of all and want to apply for the fee waiver and are not sure whether they'll be eligible. So it's very important now the fees are so high that you understand how you qualify for the immigration fee waivers. How can you explain to people what is needed for that?
What I often tell people, and it applies to fee waivers and when you're in a situation where you're applying for recourse to public funds. Now, the policy states that you need to show that you're either destitute or homeless. But also, in proving destitution and homelessness, it's not as easy as it sounds. So, for instance, you could be here as an overstayer. You don't actually have a bank account. So how do you prove what money you do have or you don't have if you don't have a bank account? Because the way the Home Office, the immigration rules are designed, is the burden is on the applicant to provide that evidence. What I often advise people is if they are receiving support from social services in terms of housing or social welfare support from social services, then a letter from social services confirming that situation is often more than enough to demonstrate to the Home Office that you are in fact destitute.
Okay. So social workers, charity organisations, support groups that are helping you can write letters. Friends who say you're sleeping on their sofa, that they've helped you out, may go into supporting that. Also an income and expenditure schedule to show that you will never, despite whatever little donations you're getting, will be able to cover the costs of any application, also are quite important pieces of evidence. And then that also goes towards the removal of the no recourse to public funds. So if you have no recourse to public funds and you are struggling, you can apply to have the no recourse removed also. Especially if you have children, don't give up on trying to make sure this is removed. There are some organisations out there that can help. Some of them are not very qualified. I remember at one stage in our office, local authorities were referring cases to us because we were getting the no recourse removed and they were not. And at the same thing, you know, when it comes down to the fee waivers, again, you've got to be persistent. If you know that you are suffering and you could qualify under a certain route, go for the fee waiver so that you can try and get yourself settled and stable. Now, appeals. Please listen carefully. If you have been refused or you know somebody that's subject to automatic deportation, so somebody that's in detention, please listen, because it's so important that you understand how the appeals regime works in the UK. One, there's a cost to it, and two, at times you may put in an appeal, but you may also put in an application, especially if you're coming close to something like 10 years. Right now, the appellate authority is actually at times reviewing cases. Why? Because almost 70% of appeals were being allowed. And that takes up court time. They were being backed up. So there's now like a filtering process where cases, once you've paid your appeal fee, which is usually £140, especially if it's not anything to do with asylum or refugee status, it then goes on and actually sits and waits for a hearing date. But in some circumstances, the appellate authority is actually filtering out cases and looking and thinking, this is going to win. Do we need to take up court time and costs? Actually, Home Office, you look at that decision again. So thank goodness that is actually taking place. But some appeals are subject to being processed out of country for certain reasons. And again, if you're being subject to automatic deportation, please listen in. So many families, already when you have a relative that has been incarcerated for an offence, find it difficult to to manage the family unit. Number one, you've got to go and try and visit them. Number two, if you've got limited income, there may be travel costs involved. Number three, there's the emotions. You don't want children to see the person detained. But all of these factors we've seen in the case law have a lot of importance on the outcome of any detainee's appeal.
What I would say is the first thing that should be noticed, especially in terms of people who have been convicted of a criminal, who have received a criminal conviction and been sentenced to a term in prison. What the Home Office will often do is send you out a letter of notice notifying you of your deportation or the intention to deport. As part of that letter, you're often asked to submit the reasons why you believe you should not be deported from the UK. Now, what I've found is it's very important that the person on the receiving end of that deportation order needs to complete the form that's attached to it and needs to ensure that they make those submissions. And it's not just enough to make those submissions in terms of saying, oh, well, I have 2 children, I've got a partner, we're a very close family unit. You need to provide evidence. Because if you do not provide evidence such as birth certificates of your children, the Home Office will actually refuse it and say, because you have not provided that evidence, we do not accept that you actually have children that are British or that you have children at all. Now, even supplying that evidence, it's often the case that the Home Office will still maintain that decision to issue a deportation order. However, what you supplying that evidence and making those submissions does is it forces the Home Office to grant you an in-country right of appeal. Now, if you don't supply that evidence, you may still get a right of appeal, but what it will say is you have an out-of-country right of appeal, which you can only submit once you have left the UK, and you must submit it within 28 days of leaving.
Now, when you go out of country, it must be, well, it is awful in trying to carry out the preparation for your appeal. You can imagine not being in close proximity to your family, being emotionally distressed, the trauma of going into a new environment, especially if you've been in the UK for a very long time. Then the difficulties, communication, internet access, filing applications, booking the courtroom, making sure that there's a video link. All these things have been tested in the courts to determine whether it's possible for someone outside the UK to actually have a fair hearing. Is it possible?
It is possible with much difficulty.
Much difficulty, yes.
And that is part of the reason why my advice is you always supply as much information about your family life and your family relations in the UK, because the reason that the government had to change their position in regard of out-of-country appeals was because of a decision of the Supreme Court, which mandated that people who have been convicted but have family relations, and what had actually been looked at was how easy is it for people who are appealing from outside the UK to participate in those proceedings. And what was discovered was that often the tribunal system in the UK and the technology that you may use abroad to have a video link is not compatible. So if it's not compatible, you can't have that video link. Also, it was discovered that often what is needed, even if you manage to overcome those hurdles in respect of the technology side, is that the government here need to get permission from the country where the video link is going to take place to say that we can use UK jurisdiction, because you're part of that court process.
Exactly.
So even though it's via video link, that means you need to come under the jurisdiction
It's
of
a hearing.
UK law.
You are in another jurisdiction. So there was not the proper, let me say, equality impact assessments, as is often the case that was done in the UK when they made these rules. So many of these rules are being made without proper equality impact assessments. So diaspora communities, ethnic minorities suffer adversely, and often it's only when it gets to high court legal challenges, and not just the high court, not even court of appeal. Some of these cases have to be pushed all the way to the Supreme Court for the Supreme Court to say, look, that's not fair. And to get cases to the Supreme Court, it does take a lot of money and time and expertise. So how many cases have you run to the Supreme Court?
I've actually only had one that has got to that level, but that was not because of my work, in terms of we didn't make the application to the Supreme Court. What had happened, and it was a deportation case, is we won the case at the first tier tribunal. The government, in their wisdom, appealed. We then went to the upper tribunal and won. The government then appealed again for a third time. So we went to the Court of Appeal and we won again. And the government, in their wisdom, then decided to appeal to the Supreme Court, and we filed an objection against the submission of that appeal. Currently, what had actually ended up happening a few years after the application to the Supreme Court was submitted is that the Home Office, in their wisdom, decided that they didn't actually have a case, and they chose to withdraw.
So we've seen that Brexit is likely to happen, may not happen, and whether there is a hard Brexit, a cold Brexit, we've been told now that we can use our passports when going to other countries, other European countries. So don't cancel your summer holiday to Costa del Sol or wherever you were going to go. That's quite good, but I think there's going to be still some discussions as to how that's going to apply. And that's what's difficult for immigration advisors, because you want to give people certainty when it comes down to advice. And even in business now, it's getting harder to sort of really channel in and say to people, well, do this or do that. And we've seen Nissan pull out of the UK, or pull out of making the particular car they were set to deal with. And that's the same for individuals. That's a big multinational company, but for individuals and families that are just simply trying to plan their lives, Brexit's having a massive impact. So those of you who have been actually given false information, that are UK nationals, being told that you can apply for dependent non-EU nationals to stay with you in the UK, please be careful, because there's only two limited circumstances that can happen. I've had so many clients come with this false, and this seems to be the latest false rumor that's been pushed around circles to undocumented people. They're being told that you can depend on your UK British national. Please clarify this for them, because I don't want people spending money and getting themselves into trouble.
Okay. The position is if you are the primary carer, so the main carer of a British citizen child, and there is not another relative in the UK able to look after that child if you were forced to leave the UK, then you can get what is termed a derivative right of residence, or what your viewers would more commonly have heard is Zambrano.
Yes.
And basically that's it derives from EU law, and it says if you have a British citizen child who can only enjoy the status that citizenship brings if their primary carer is in the UK caring for them, but you have to prove that you are their parent or their guardian, and you have to be in a situation where there is not another relative able to care for them. I would qualify that, however, with the fact of if it's two non-EU parents who neither have status and they are together, they can apply jointly
Yes.
for that derivative right of residence. However, if one parent is British and one parent is a non-EU and they're not together, then there is a risk that the Home Office can say, you know what, the British citizen parent can remain and look after the child, and the other parent has to leave.
Have to be very, very clear on what the law says. Okay. So the other thing about that is that status going to be something that can lead them on to indefinite leave to remain, or is it something that's temporary? So, for example, you've got the British child. You are able to say, look, this child has to stay with me and live with me to enjoy the rights of being here in the UK. I'm the carer. And it's a cheap application to make. It's a lot cheaper than doing, for example, FLR-FP. It's over £1,000 cheaper. But what status will I get from it? This is the problem. Many people don't realise what status they get from doing that.
In respect of a derivative right of residence, the way the UK government has interpreted that is, yes, you will be given status, but it only lasts so long as that British citizen child is under 18 or till they're 21 if they have remained in full-time education between the ages of 18 and 21.
What about if you're caring for an elderly person?
Okay.
Somebody who's elderly or infirm?
If you have an elderly parent
British,
or an elderly relative that is a British citizen and you are the non-EU national, you can also apply for a derivative right of residence. What I would say is it's quite technical in terms of the level of evidence that the Home Office ask you to provide. So, for instance, it's important that you provide evidence to show your relationship with that British national. If it's if it's a parent, elderly parent, you want to provide a copy of your original copy of your birth certificate so it can be seen that, look, this is my mother, my father. You also have to provide further evidence in respect of what efforts you have made to obtain care for that family member.
The funny thing is the government then looks, when they're looking at these cases, and sometimes say, oh, well, social services can support, and often you have social services saying, no, we cannot care for this person, allow this person to stay. But again, because of conflict between government departments and depending on how cooperative your social worker may be, may determine the level of evidence that you get. You may have to get an independent social worker's report to confirm your position. And again, going out there, making sure there's enough experts or the right experts to give evidence in support of your application is important. And sadly, you may have to pay for that evidence. You may have to have the extra funds to have an expert social worker, doctor, prepare a report to support your application. Now, I have said that I'll put the phone lines on, so you can call in if you've got questions. I have also got Mr. Muirhead, who can give you his email address. So if people want to get hold of you, how can they best get hold of you?
Okay, the best way to get hold of me is to email me at Marcus, that's spelled Marcus, at OBASEKI, OBASEKI, solicitors, all one word, .com.
So you can email Marcus at obasekisolicitors.com and you'll be able to get directly through to him. We do run a legal clinic and it's very popular every Friday at our office. It's limited, so you've got to try your best to book, otherwise when you come you may wait. But the legal clinic doesn't just cover immigration, it covers all areas of law. So that's housing, welfare, property, family. We're having a lot of private client now, so your wills and probate, but it's limited to 15 minutes. So don't come in with your serious problem to deal with your £5 million house and expect to sit down for more than 15 minutes and get free legal advice. And we do look at the people who are most vulnerable, and the whole idea is to try and give them a sense of direction and clarity with regards to any problem they may have. So if you don't get through on the phone lines or you're too shy to talk about what your problem is, that's not a problem. just call in either at OBASEKI Solicitors. You can email Marcus directly, or you can send an email through to the info@obasekisolicitors.com. But regardless, somebody will get back to you. Now, before we close up, it's about really giving people clarity on some of the confusing issues. We have talked about the deportation, and voluntary return is something I really want to talk to people about, because there's a lot of stigma. Some people will tell you, oh no, you've been here for 6 years, don't worry, when you're 10 years you can get it. No, you can't. It's not automatic at 10 years. Or some people say, oh, you've been here for 13 years, you can still try. Again, even if you've got a young child at that point in time, it's not really automatic. So if somebody is like, do you know what, I can't afford the application fees, we're living on people's sofas, if I go back home and if this person and that person all chip in and they give me £500, £1,000 each, it's going to be the same as me making an application. And an application for you is going to be £2,033. For your child, if you do put your child on that application, so that's over £4,000. And that's without your lawyer's costs. If you think in your mind that, you know what, if I take that money, try and get someone to also pay me house rent, pay me a shop rent, or do my CV up, go and look for a foreign company or an emerging company back home that will recognize my skills, my qualification, let me just go back home. What should people do if they think that that is a choice they want to make?
It's a highly personal choice, but what I often advise people is when making a decision like that, they need to weigh it up against the likelihood of them having a successful application.
Yes.
Because the issue you have is you may even be able to raise the money to put in that application at £4,000 plus, but does your application have a chance of success? Are you prepared to live underground for the next 10, 15 years until your situation becomes one where you do qualify?
Can I just ask you there? Now, I know, and I make it a practice within my firm anyway, to tell people what their average percentage chance of success is and qualify that. Because I believe strongly and ethically that if you're giving somebody advice and you know what you're talking about, it's not 50-50 so that the person makes a decision. If it's not 50-50, then should a lawyer be able to say in this day and age, if somebody presents their situation to them, what percentage chance their application has in succeeding?
Yeah, I believe so.
I do too. So just be careful out there when someone says, well, it's 50-50, it's up to you. I can do an HR application for you. Be very careful. Or I can do a dependency application. You can depend on your British person or British relatives family. It's not always true, so be careful.
The only cases I would say which are 50-50 are deportation cases.
Okay. I think we have a caller. Good evening, caller. Can we help? Have they run away? Good evening. I think that one's run away. But you're saying on deportation cases, maybe 50-50?
I would say those are the cases that tend to be 50-50.
Okay.
Because they're unpredictable.
Hello. Good evening, caller. Can I help?
Hello, good evening. I just want to find out about somebody, a friend of mine, had a problem with immigration some years ago in Manchester.
Yes.
And he was actually arrested and was actually signing on.
Yes.
So he ran away. He wasn't signing on then.
Okay.
He came to London. After some years, he got settled down with a baby and has 2 children. Now, when the time comes,
Yes.
do you think he can take the position based on the fact that he didn't sign when he was asked to sign on?
Right. 2 things. You said that he's making an application with the child and the wife?
A 7-year-old.
All right, then. Sounds like the partner also doesn't have documents in that case.
No, the partner was on asylum on a separate application.
I see.
And he gave her 5 years.
Okay, so the partner and the child, the child is part of the mother's application?
Yes.
Okay.
The dad is separate now. The application is presented with the 7-year-old first child is separate from the mother.
All right, we'll answer you now.
Okay, just I wasn't quite clear. Did you say that the child is included in the mother's asylum
For
application?
some reason, the child separate.
The child is included in the mother.
Okay, and the father's separate.
The child was, the child has always been with his mother separately.
Okay.
So now that the child is
Mm-hmm.
they're going to use the 7 years to
Completely wrong.
year-old thing to apply for the child.
I would advise them not to use the 7-year rule, and
They've already submitted their application.
well, I can't help that. But what I often say to people is the 7-year rule is written in such a way that it essentially reads: if you are a child and have spent the first 7 years of your life in the UK, and it would be unreasonable to expect you to leave the UK, then you should be granted leave to remain. Now, the courts have made a number of rulings on that, and it's a pretty high bar to demonstrate that it's unreasonable to expect the child to leave, because what they say is you're going to a country of which you are a citizen, of which your parents are citizens, of, in many cases, your parents have spent the majority of their lives in that country. So while it's accepted that it will impact upon your human rights, in the interests of having a fair and effective immigration control, it's deemed reasonable to expect that child to leave the UK and go back home with their parents.
Caller, can I say to you one thing? It's important that whoever has the immigration problem actually speaks to the lawyer directly. So if they have further questions, please ask them to approach us directly. Thank you very much for your call.
Thank you.
Stay blessed. Now, this is another prime example of where somebody makes an application and sadly they don't realize that they don't actually qualify for that application. That gentleman in that scenario may have a right to remain based on the fact that he has a relationship with a child that's present in the UK and the child is not able to leave because the child's subject to an asylum application. But was his case presented in the right way? Was the evidence galvanized and packaged and put together in the right way? We're not to know. But hopefully the gentleman will get the right advice and do the right route. And if he's lucky and he gets an in-country right of appeal, he may be able to put those submissions through under a human rights submission in part or parcel of his asylum or his appeal against such a decision. But it all shows you that these cases are not straightforward, and it's always important to go to an experienced advisor before making an application. You don't just simply make an application based on 7-year rule because you've got a child in the house that's 7 years. So, yes. Any other thing just before we close?
I think the biggest thing that people need to be aware of is, as applicants, the way the Home Office, the way the immigration rules are designed, and it's been confirmed by a number of different court decisions, is that the burden is definitively on the applicant to provide the information to satisfy the Home Office that they meet the rules.
Okay, but there also, am I right, is case law that where the Home Office may be, or the government may be in possession of that evidence, that there should be a level of cooperation and disclosure?
Yes, they should be. I mean, what I would often say is there's a number of judgments that are kind of contradictory, but in the main, everybody should always approach it as if the burden is on themselves.
Yes.
And that's the best way to approach.
So please, some of the things that came out, if you're a Commonwealth citizen and you still have not really thought about whether you had settled status before 1971, and you think you may fall eligible for Windrush rules, speak to us. If you think that you're a child of somebody who is again in that category, even if they're not in the UK, you are here, but you think your parents were settled previously in the 70s, and you think you may benefit as a second generation Windrush, speak to us. When it comes down to your appeals, if you're not sure whether to appeal or put in an appeal and then subsequently put in another application, speak to us. If you're not sure of the category of application you think that you need to make or that you fall in, get clarification. Naturalization, be very sure that you have clear history of good character before you spend that money, because it's a lot of money. Fee waiver applications and removal of no recourse to public funds, we can assist you with that. Now, before I go this evening, I'd like to say thanks for joining us again. But as I've said, future programs coming up, letting you know that dealing with knife crime, if you've got a child that you know needs help because you've seen things around them, you've seen things in their bag, you've seen activity, you want to get help with regards to them being groomed, removal from gang activity, do call in, speak to us. We're going to try and make sure that anybody in that situation is not wanting for help and get support. Children going into upper education or trying to get into secondary schools, what applications you should make. We're having some experts come in the next few weeks to talk to you. And then people who are into creative enterprise, who have products, new innovative organic products that you need to know about, we're going to be showing them to you. So thank you once again for joining us on Truth and Justice TV. Been very happy that you've attended our lovely little session today. Any further questions, you can email marcus@obasekisolicitors.com, or general questions that are not to do with immigration, you just want to ask us to do with housing or welfare or property, you're buying, you're selling, or commercial disputes, email info@obasekisolicitors.com. And we will see you again next week for another live innovative show. So be good, and if you can't be good, be careful. Stay blessed.
When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. OBASEKI Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com.